the Supreme Court has handed down decisions on cases involving free speech and Fourth Amendment rights against illegal search and seizure. So we want to bring in CBS News legal contributor Rebecca Roy for you to break down these cases. Rebecca, thank you so much for jumping in. So the first case I want to talk about is Mahanoy School District versus BL. It's a school district in Pennsylvania. I presume BL because the individual involved is a minor, so we only have the initials. Can you break down this case? It's a cheerleader versus the school district. What did the court decide?
That's right. So in short, the court decided that the school cannot regulate the speech that was at issue here. And this cheerleader was disappointed because she hoped to make the varsity team and she didn't make it. She then went on Snapchat, which is an app that issues sort of quick statements that are then destroyed in 24 hours, or she thought, but somebody took a picture of hers and sent it to the coach, who then said she couldn't be on cheerleading at all. So she brought this suit challenging the school's ability to punish her for speech made while she was off campus. And the court decided narrowly in this case. The ACLU was representing the student here, and the ACLU wanted the court to say, you know what, if the speech is off campus, then the school cannot regulate it. Instead, the court said that the school just didn't have a substantial enough interest to regulate the speech at issue here. The student had just kind of issued some profanities generally about school, about cheer, about teams at school. She didn't even mention the school name. So the court said here, it hasn't reached that point where it is substantially disrupting the business of the school, but did not say, it stopped short of saying that off-campus speech cannot ever reach that standard.
So what does this ruling, Rebecca, mean for students who want to post on social media going forward?
Tread cautiously. I mean, it certainly gives some leeway to students to post what they want to post when they're not in school. But it also, it stops short of saying, you're completely free to do whatever you want. This is a really, really important case because, of course, every First Amendment case is important, but this is about schools. And I think Justice Breyer said some interesting things here. First of all, there's an increased interest that schools have, or an increased role that schools are playing in regulating speech through this effort to address cyberbullying and through anti-racism efforts. And so the opinion did not prevent the school from pursuing those policies, but it did say, you know what, you have to be careful, especially when students are posting on social media. So, it kind of split the difference here, and it made it a little bit hard for students to know what they can and cannot do. What I would be very careful about doing if I were a student is posting anything that is directly concerning their school, naming their school, and I would be very careful about these sort of hot button issues, because I think that the court might go a different way if what the speech involved were things that were directly affecting the school's business. And I also want to pause for a second and say one of the things that Justice Breyer said that's so interesting here is, he acknowledged that schools have a real interest and concern in preserving the educational atmosphere and making sure that things are running properly in the school, students feel safe within that school. But he also said schools play a fundamental role as nurseries of our democracy. This is the future of our democracy, and so it ought to, at the same time, value and promote free speech. How do we balance those two things? Well, the court really said we have to do it in a very fact-specific way.
So I understand how, schools should have the ability to manage behavior that may be disruptive to the school, whether it happens on school campus or off school campus. But I was wondering whether or not this ruling would have an impact on people who are out of school. It seems like it's not going to, but I'm going to ask this question anyways, because, we've seen people lose their jobs for sharing a meme or making a comment, or people lose, political positions or positions they were appointed to because of that sort of behavior. I mean, does this go on? I mean, does this have an impact outside of schools and into the workplace, or is it strictly just about the school environment?
So again, the First Amendment is such a complicated thing, and that it really does depend on context, in part because, each different context, the government interest is different. And because of this constitutional provision, we're very concerned when the government in any form tries to interfere, especially with the content of somebody's speech. However, the government's interest varies in different contexts. So we really can't generalize from this decision elsewhere. This is really a school-based decision. And, adding on top of that, it's not only a school-based decision, but it's a school-based decision that really parses what kind of off-campus speech students can engage in with this sort of protection and what they can't. And it is a little hard to know what the school did give the court did give some guidance on the parameters of this protection, but it is not complete, and it certainly does not necessarily apply in different contexts. The rules would vary depending on what kind of government activity and what area of government was making this effort to interfere with somebody's speech.
I also, Rebecca and Anne-Marie, am fascinated by the details of this case. Brandy Levy, I believe her last name is, who was a 14-year-old freshman, when she expressed her disappointment, like all young people do if you don't make the team. She didn't make the cheerleading team. She went on Snapchat and she let loose the way you probably would in the era before Snapchat when, I didn't make the football team, I said much the same, but I said it in person. I said it in the school cafeteria. I said it to whoever. I said it to the coaches that I thought, that they were losers, even though I was in fact the worst football player in that high school. But I, what makes me wonder is that how does something like this, which happens across America, make it to the Supreme Court? I mean, just in the process by which a teenager has a very teen moment, next thing you know, you're arguing before the Supreme Court of the United States and setting precedent, because what you were talking about is precedent going forward. It's going to affect a lot of people, and not just teenagers in school who are angry about something that doesn't go their way.
Absolutely. Well, this is the way law is made. And, especially because, as you say, social media changes things. And as the world changes, the Supreme Court has to revisit its rules and talk about how do those rules apply in these different kinds of contexts. But, in terms of the sort of what I was sensing to be the sympathetic view you took toward Brandy Levy, you weren't alone there. And I think, this is not a case that broke down on ideological lines. And especially, you saw during the questioning, Brett Kavanaugh, who himself was an athlete and also coaches girls basketball, he also felt sympathetic to this girl's outburst. And so, this was a way of addressing it in a narrow way so that the precedent that's set is not too broad. And if another case arises where the speech is different, more closely directed to the school, or, somewhat closer to campus or during school hours, things could be different. And again, it is a little bit unfortunate in that this doesn't give a whole lot of guidance because it is so fact specific, but I think it's really hard to avoid that in this context. When you try to draw lines like on campus and off campus, and there's social media, it's almost impossible to do that because social media is everywhere. I mean, social media, so if somebody was in school Snapchatting, it would be different from whether they were 2 feet, across the street.
Yeah, I think I know we got this other case that we got to sort of go on to, but in some of my readings, if I recall, the Supreme Court has already kind of weighed in on this way back in the 60s when I think, Rebecca, you would know this better than me, there were students who were protesting the Vietnam War and they wore black armbands to school. And the court ruled that, that students do have the ability to express themselves even on school campus, as long as it's not too disruptive to school. So I would think this is just an extension of that, with this new technology that now you have a public forum anywhere you want to have a public forum on with these social media platforms. And so you should still have the ability to say what you wish, to a certain degree, because we are still talking about schools and students and developing minds.
Exactly. So you pinpoint the precedent that's relevant here. Exactly. And that's the question. The question is whether there was a substantial disruption of school work. The reason why that is the standard is because we're trying to balance these two things. The school needs to be able to do its work. It needs to teach its students. It needs to function. And we acknowledge that. Yet, we have this free speech interest at issue here as well. And so all of this is an attempt, that case was an attempt to balance those two interests. And now we're revisiting how to balance those two interests, given that communication has become so different in the modern era.
Okay, case number 2, because we got a lot out of this. So case number 2 has to do with a person who was convicted of driving under the influence, but it's where that test occurred that is of issue. The justices unanimously ruled in favor of the drunk driving suspect. An officer pulled him, saying that the officer trying to pull him over needed a warrant to follow him into his home. Explain this case to us.
Right. So the individual here, the defendant, was driving. He honked his horn very loudly and listened to some music, which apparently is a traffic infraction. And so the police followed him and they put on their sirens. Instead of pulling over, he pulled into his own driveway. He walked into his garage, and as the garage door was closing, the police officer put his foot under the sensor. The garage door opened. The police officer walked inside. So there is a general rule that I think most people know, that in order to go inside somebody's house and search around, you need a warrant to do that. But there are some significant exceptions to that general rule. And one of the significant exceptions, more very broadly stated, is when there's an emergency, when there's what we call exigency. And so in hot pursuit is often seen as a kind of exigency. Somebody can't escape the police by running away and shutting the door in the police officer's face. The police officer can then open the door. But the question here is, well, does that exception apply when this is a very minor misdemeanor case? Can the officer automatically go into the house because somebody has essentially evaded arrest? And the court here said no. Again, fact specific, not creating an absolute rule that the police officers can never follow somebody in the house. The court said you have to look at the specifics of the case, and the government has to establish that there was actually some kind of an emergency. And so the court said, sent it back down to the lower court saying, was there a real emergency here? In other words, what would have happened if the police officer had done what he was supposed to do and gone and gotten a warrant? Would something terrible have happened? Would evidence have been destroyed? Would somebody have been hurt? Would something else have happened that would have triggered the need to go in immediately? What the court refused to do is say the mere fact that somebody might evade arrest when it's a misdemeanor itself constitutes that emergency.
We're expecting some other major decisions soon, Rebecca, as the court's term comes to a close. What are you looking out for?
So one of the major cases we haven't yet seen the decision on is the voting rights case. And that case, it comes out of Arizona, and there is a challenge to 2 Arizona laws that are restricting in some ways access to the ballot. And those laws at issue there have to do with who can return a ballot and what happens if you vote outside your own precinct. The question is whether those rules violate Section 2 of the Voting Rights Act, which prohibits discrimination based on race. And these 2 rules are important to Arizonans, but this case may very well determine the future of all these laws that are cropping up across America that are supposedly addressing fraud in voting, but disproportionately affect minority voters. So there may be an interpretation of that clause of the Voting Rights Act that could determine which of these laws will survive and which will not. So we all have our eyes out for that opinion and are waiting for it to come down.
All right, Rebecca, always great to have you break this down for us. We so appreciate it. Thank you very much.
Thank you.